Hey, Steve, welcome back.
Thank you, Dave. Thank you very much. Good to be here.
Yeah, we're for those of you who were on our last webinar, we were sitting next to each other and decided to go remote on this one and save a bit of driving around town. But excited to be kicking off the conversation again. So thanks for joining me. We're going to make this a continued regular thing because there's just so much happening even in the last 2 weeks since we talked. You want to kick off there, Steve? What's going on in AI law these days?
Yeah, thank you very much. It's great to be here. Great to see you. I thought we'd kick off today. Governor Newsom in California has, I don't know, probably 6 or 8 different AI statutes which have passed, but not enacted, of course, until he signs them. So really, there's several. And I was going to touch on one and spend a little time on the second one. I think both of these will get signed. And I think it's worth noting what they are. So the first one is an Assembly bill, AB 2013, called the AI Training Data Transparency Act, AI Training Data Transparency. And what it applies to anyone that develops an AI system that is intended for use by members of the public. So this is pretty much a generative AI play. And the note worth noting is that it requires that the developer post documentation on its website explaining the data that was used to train the generative AI system. And that documentation includes the sources and uses of the data sets, how they fulfill the purpose of the system, the number of data points, the types of data points, whether the data set includes data protected by IP or personal information, whether there's been cleaning, processing, or modification. So we're headed into like disclosure obligations. And this is just one more example of how the state laws and regulations, and certainly federal, we're headed into a whole kind of analysis of impact assessments, risk assessments, data protection assessments.
And for context, Steve, most of the big model builders have not been saying where they got their data to build all these models.
Oh, is that right?
Like OpenAI, Google, there are some of the open source ones have published where they got all the data, but I think most of the major ones have not said. I don't think Meta has either said exactly where they got the data from. So this is kind of a big deal for the large language models out there, and that any of the generative AI that are training on massive sets of data, right?
Yeah, and of course the key, if you pull down those systems, open source systems, and then integrate your own data and modify them, then you become the deployer and must pass these same kinds of disclosures and explanations down to your users and licensees. Yeah. And that's the key part for anyone developing this technology, to take this into account early and begin to plan for it.
Yeah. When would the law go into effect if signed?
Good question. I think since it's a disclosure, I would expect, I don't see on my little blog what the date is, but I think it would be 90 days or something.
Yeah. Okay.
Because it's disclosure. The other one is AB 1008. Assembly Bill 1008, which amends. It's a simple in some sense, but I think it's significant in its impact. It would amend the California Consumer Privacy Act to merely add one provision that says personal information can exist in various formats, including obviously physical data, digital data, and here's the key part: abstract digital formats, including compressed or encrypted files, metadata, or artificial intelligence systems that are capable of outputting personal information. So effectively, personal information contained within an artificial intelligence system remains as personal information for purposes of the data subject rights that CCPA is granting to your users of their systems. So I know you had a particular couple of points. The one, as I parse down into it, it's any personal information contained in an AI system that is capable of being outputted or accessed. So tell me your thoughts about that requirement.
Well, so yeah, this is a tricky one because when a large language model in particular, I mean, I think we're mainly talking about a large language model here as far as something that might output PII. So,
Right.
you build a model and it is trained to statistically figure out, which word, which token comes next. And there's some probability and it's coming up with averages. So in general, if you say, hey, give me the phone number of John Doe, then it's going to make up a phone number that is the type of phone number that John Doe might have, right? So like if I explicitly asked for John Doe, I would almost expect to get a number that starts with 555, right? Because John Doe is used for an anonymous person.
Right.
But if I ask for the phone number of Steve Britt, if your phone number happens to exist a lot alongside your name inside of a system that was trained on a bunch of data that has PII, then there is a possibility that the actual real phone number will come out. Usually it won't. And I was doing a little bit of digging on this because I think it's fascinating and there's some debates. There's a recent paper entitled PII Compass, guiding LLM training data extraction prompts towards target PII via grounding. It's the name of the paper. So what the technique basically is to get more accurate results out of an LLM in general. If you give a bunch of examples of the types of things you want, you're more likely to get the result that you're looking for. And it turns out this can be true of an LLM that's trained with PII data in that if you ground your prompt, meaning if you give it a long list of actual real world names and phone numbers, they've proven out various techniques that up to about 6% of the time, with all of the techniques that they've used, they can actually get the real phone number of an individual out of the LLM system. So there's still a lot of probabilities there. There's still a lot of randomness in the outputs. It's very far from like a database lookup that says, hey, give me Steve's phone number. But it does prove that the PII can exist inside of the model, even as it is crunched down into these floating point number matrices that make up these large language models that represent the language. There's still just enough in there that you can pull something out of it.
Right. So it's effectively making the personal information, if it is contained within a model and capable of being accessed or output, it makes that data subject to the full scope of CCPA rights. Which means the ability first of all, for the company to track, is it possible for it to be output and which specific personal information? Because if the user comes and says, please delete my data or opts out of your use of it for these purposes. So some of the blogs talk about what is the way to deal with not having to retrain your model, if it's even retrainable. And of course, one of the main thoughts is train models without the use of personal information. So maybe that's synthetic or, I don't know. What's your...
I think that's the obvious answer is, if you shouldn't be putting it out there anyway, don't stick it into your model. I think the main reason this exists is that models are being trained on large swaths of scraped data off of the internet.
Yes.
And it hasn't been necessarily parsed for PII. For normal uses of a large language model, though, there's really no reason for me to need your actual name and phone number.
Yes.
Like, what is the purpose of that? It's just that we've sort of somewhat lazily built these models. Certainly, if I'm collecting my own customers' data, there's no reason for me to stick all of that personal information into a language model. So yeah, I think the right answer, you add on top of that this requirement you just mentioned for disclosing what data you're using.
Yes.
Well, obviously, we're going to disclose whose data we're using to show this. And if it says you're using a bunch of people's, customers' phone numbers and addresses, then yeah, obviously don't use that. I think
Right.
that's the simplest
Right.
answer.
I've got one quarrel legally, purely legal, but the definition that says it includes abstract digital formats in AI systems, but it says including compressed or encrypted files. Now, encrypted files are generally the exclusion from the definition of personal information if it's anonymized, de-identified, aggregated, or encrypted. So I'm a little confused that this bill received the support of the California Privacy Protection Agency as merely reflective of existing law. So using encrypted file as saying if it's encrypted, but it's in the model, it's still subject to these requirements. That seems a complete conflict with the idea that encrypted data pulls it out of the definition of personal information.
Well, so there's a difference between anonymized and encrypted. So
Yeah, sure.
there's a way that I can take all of the personal information and, aggregate it together to say that, people from this zip code tend to be like this, and take out all the names and all the email addresses and phone numbers and things like that. Encryption doesn't necessarily mean that you can't de-encrypt it, right?
Exactly.
So that, I think that would be the major question here, and there might be some weirdness in the legal terms there. But I can encrypt something. I mean, all data stored at rest, ideally in a secure system, is encrypted, and in transit is encrypted. But if I've got the key, I can decrypt it.
Yeah, so maybe it's picking up on the other parts of CCPA that as far as sharing third-party data, the third party must agree not to make an attempt, whether it's de-identify and no attempt to re-identify, and certainly would apply to not attempting to decrypt it. So maybe it's drawing on those portions of CCPA and the fact that it's encrypted at some level, which certainly doesn't keep you from decrypting it. Yeah, so that's a good thought, but it does seem like it's personal information capable of being output. So maybe that also narrows the universe of the complications of data subject requests.
Yeah.
I say the CPPA, the now only in the nation dedicated data privacy regulator, which is in California, says in their position paper, one, they supported this bill because they thought it merely confirmed existing law, which is kind of an interesting thought. And I've seen no discussion of the status of personal information inside a model. And some authorities don't think that personal information can exist in a model. But that aside, the agency said they're already working on draft regulations that would ensure that certain rights apply. And we've talked about, and probably worth its own session, with California's pending proposed regulation on cyber audits, risk assessments, and automated decision-making technologies. And the interesting part about that is that if you listen to the actual agency meetings, the board member of the CPPA, which is the most concerned about the scope and the breadth of the automated decision-making technologies regulation, the reason it hasn't been proposed yet, is Alistair McTaggart, who of course put the ballot initiative together resulting in CCPA. And he says in these meetings, well, who wouldn't ADMT, who wouldn't it apply to? It's so broad. So that's kind of interesting that regulation's on hold now, trying to kind of scale back the scope of the automated decision-making technologies rules that are proposed.
Yeah.
Yeah.
What would some of those effects be? I mean, as you say, that is a very broad term, automated decision making. I mean, that happens all the day, every time. Every time I go on a website, there's some automated decision making about what ad I'm going to see.
Exactly. Good point. They're really focused on potential adverse effects, or either the access to or the terms applicable to. And let me give you a list here, but it's all of the. It's access to finance, education, employment, benefits, privacy rights. I'm trying to find the easiest list here, but it's deemed high risk if it could affect education, employment, or opportunity, financial or lending services, of course, loans, mortgages, essential government, healthcare services,
sure,
housing, insurance, even legal services. So if it's got a potential, the Colorado Act calls that a consequential decision. If it either affects or could be used in making a decision that's consequential, and it's really all of these potential adverse effects on, education, employment, jobs, health,
Sure,
those kinds of things.
Yeah.
So again,
back to my example, they don't necessarily care which ad I'm going to see on a website. That's fairly inconsequential. But if my information is going into some machine learning system that's going to say I get a loan or I get into college or things
exactly,
of that nature,
or you get a job, it analyzes the applications as to whether they're going to get a job offer or capability. And again, even the EU AI Act, this whole basket of really disclosure of the fact that the individual is dealing with a machine. So a lot of transparency beyond that, as long as they know that don't trust the data and it could have been manipulated. Generally, that's all that's required in those areas.
Sure.
So these all both get signed, I'm sure.
Okay.
The agency supported the personal information systems. And again, I kind of looked at you on the technology side as to how big a problem is that going to be for developers and deployers?
So it depends on what you're doing, but I think the people that this is the biggest challenge for are the ones who are scraping millions of websites and not been completely sure what the models have been trained on. And it's not something that they've disclosed in the past. So how big of a challenge is it going to be to do that is an interesting question. There's ways to automate this too. So there are a bunch of tools that have existed for a long time for discovering PII and PHI in your data. Just looking for patterns, right? Using a regular expression, one of the coding approaches to finding things that look like social security numbers, right? And, or things that look like phone numbers and surfacing that so that you can then remove it or obfuscate it in some way. So there's a lot of existing tooling to try to get that problematic data out of the system. The biggest thing is probably going to be for the models that have already been trained. If that goes to court and they say, well, GPT-4 is now illegal because we've been able to prove that there's some PII in there, there's no quick, go back and retrain it. These are the models that take, entire buildings full of GPUs, hundreds of hours to go and build and train that. So, I could imagine, I don't know that it would happen. I'm interested in your opinion. Is that going to go to court and be the case? They can always build new models, but there's a whole lot of models kind of out there in the world now that might run afoul of this law. And, do they have to be taken down if this goes to court? Like, what's the likelihood of some challenge there?
Yeah, there's certainly, the New York Times and OpenAI, and the question is, the legal question at issue is it a fair use of copyright information to use it into training models? And the defenses of those lawsuits are saying, no, that's a transformative use. It's not really, it's changed the form in a manner that it hits the fair use exception under the Copyright Act, which is not really what that fair use definition was intended for. But so it does seem like there needs to be some fix here to avoid, when ChatGPT-3 and shortly thereafter, each of these large developers provided indemnity, we'll indemnify you if you're sued over infringement for your use of our tool, as long as you followed our rules.
Right.
I thought, how could they do that? Because the models are scraped and used, but like you say, if there's technical ability to secure and analyze and pull the personal information out of it, maybe that's part of it.
I think that's an easier one than laws saying, an entire sort of family of where you might get content from. Actually, I think it's probably even more complicated to look at the disclosure, right? So if you've got just thousands and thousands and thousands of sites that you're looking at, that could be quite complicated to go sift through.
Yeah, they're certainly all headed for assessments and disclosures that the regulators are going to have access to prove that you've done a proper prior to deployment or use of the system, that you've met all these compliance requirements. So I think the main message for anyone developing any kind of AI tool or system is to plug in the regulatory reporting and accountability requirements, explainable, transparent, secure, human-centric. I think those, and the regs are certainly reaching to saying that the individual, the California regulation would say the individual has the right to opt out of the use of automated decision-making technologies for that decision as to them.
Yeah.
Whoa, man, that becomes very granular.
Yeah. Yeah, that certainly is a complicated one from a systems design standpoint.
Right.
It points us back to, putting my product development hat on if I'm building a mortgage product or a health product. It means I need to have this branching workflow in my software that says most of the time it's okay for me to, grab some data, run it down this path through this tool. But if they have said no, then we're going to go down this other path. And none of that, like if then statements are what software is built on, right? That's achievable. But I think the biggest thing that it means is as software developers, we can't be lazy. We can't just say, hey, we're going to run this script that goes and scrapes the internet and then run it into this algorithm that we barely understand with data we haven't read that went into the training, and then trust a system to make a good decision, which you never should have done in the past. That has always been a bad idea and always will be a bad idea. But now the law says you really need to understand that end-to-end pipeline of the data provenance that we talked about last time, and your machine learning ML ops, machine learning operations practice, and what data is going in and what models are you using and how are you understanding it. So it's really formalizing things that have been a good idea since machine learning existed.
Wow, that's fabulous. I mean, I think that's the key takeaway, because I'm so deep in the legal and the regulatory, but from a technology standpoint, how do you prove this? How do you report that? And I'm always with our clients, I'm trying not to boil the ocean, have some kind of an assessment report that walks through and some evaluation of the potential adverse impacts on data privacy or risk, and do some analysis of them and impose some risk mitigation rules. Then I come back to you on the technology. Do you segregate that data? Do you keep the data for each of the models? And so the reporting and accountability requirements, I don't think it has to be perfect. I think you just need to do something and start down that road of educating yourself and rolling it into your product roadmap.
Yeah.
Easier said than done.
Yeah, it's a lot of pieces, but it's all doable.
Is it good?
There's no reason you can't understand everything that you're doing to build a machine learning model and be able to explain what's happening in there. For me, I think the trickiest thing is the chain that we talked about last time of if we have a large language model that we're fine tuning or some other model from somebody else,
right?
We're going to go put our own data into and tweak some things and then get some outputs. And that, I think, comes back to the indemnity question of it's one of two things. You either just have to trust that the foundation model that you're building on top of is okay and compliant, or you have to not trust that and you have to say, well, I either have to build my own or I have to go to a model that has followed all of these regulations. And I think we'll probably end up seeing that at some point in the not too distant future of, here's the models that have followed California and, the other laws that are coming to be able to say, no, we actually have this now and we can go and capture all of this data, and we understand where it's coming from and how it was collected and how it was used and what models were used, all of those things. And then there will be this other family of kind of gray zone models that maybe they haven't disclosed all of that, and you can use them, and they might have, I'm thinking all of the models that exist today, basically, that they haven't disclosed that. You might continue to keep building on it. They might go to court and you might have to pull your stuff down. So don't depend too heavily on that, and start to look at the models that are actually, following all of the rules.
Right. Yeah, I was going to, on the whole compliance, that it's non-biased, there's been no data drift, always testing the model, and always updating and improving it with new data. Those are all, again, on the development side, that have to be part of the development roadmap, I guess.
Yeah.
And the laws are going to require how you explain that you did that, and that data is valid and continuous and secure. And it's very complicated, and I'm not sure that the regulators are fully prepared for what they're asking for.
Yeah. We got an audience question coming in here, Steve. This sounds so complicated. I agree. There's a lot of moving pieces here. How will it impact banks, mortgage companies, research companies using this information for their core businesses, such as to predict payment defaults, et cetera?
Yeah. A lot of that's going to be, you can climb into the bowels of the laws and regs. If it's being used for internal purposes, it's really the effect on the outward consumer and customer, and being able to prove that it was unbiased. And so always testing. But, in terms of using AI systems or machine learning inside your business, it's really kind of more what you do with that output and being able to defend and justify it. On the liability side, while most of the statutes don't permit you to sue on the statute, now Washington My Health, My Data Act does have a private cause of action. But on the other hand, straight negligence and tort law is not affected. So if someone feels they were adversely affected by a decision that was made, they could sue on that. So right. You want to be able, and of course, then the plaintiffs would use whether or not your practice complied with the actual statute, not to sue on the AI Act, but to use it as a measure of acceptable practice, and whether or not it's negligence per se. If you violated the regulation, then they can make the point that it's must be negligent because you didn't follow the law.
Yeah. So, it all comes back to me. I think, it's understanding where your data is coming from,
right,
and disclosing what data you're using and what data, where you're making decisions with AI. So if you are using, my data as a bank to understand if I'm likely to default, that remains okay under these laws, but it needs to be told to me somewhere. And the tricky one is I might get the opportunity now to opt out of that.
Yes.
And say, no, I want a human to review all of this. And then, what does that mean? Obviously, I'm not going to get an instant loan approval then, right? I'm going to go into some queue where somebody is going to have to go and look through that. But that's the tricky thing, I think, is this branching opportunity to say, no, I don't want that. Don't use any AI.
Yeah.
This decision.
And again, thinking through the use case and thinking about where's the potential risk, and is it due to bias in the data or in the tool or in the weights or something. That's being able to defend and analyze, do an impact assessment on the potential risk and what you've done to anticipate and mitigate it.
Yeah.
But you can certainly envision, when the environmental statutes were first passed, they talked about an environmental impact assessment, and it was kind of viewed to be a couple of pages, and now it's hundreds. So you can readily see that these reporting and risk assessment and impact assessments is going to just grow in complexity.
Yeah.
So,
yeah.
That's why you can't really try to be perfect too soon. I would tell companies to look at the types of things which are meant to be disclosed and what the risk assessment or the impact assessment is meant to analyze. And they're, like in the California statute and in the pending risk regulation, it's like 15 different subcategories. But, pick a subset that runs across the states you're doing business in and address them, And I look to you technically on how you prove up those models, but something is better than nothing.
Yeah. Yeah. And I imagine the more people who go through this, the more we'll understand, hey, this model is very explainable in these ways. And
Right.
So this is fine to use. This model is less so. You can only use it in certain ways. And these things are understood. I don't know that they're understood at the C-suite level in a lot of businesses in a way that you can actually understand what the process is. But we'll have to track who comes up with what types of certifications to be able to go through a process where, you can get an audit and somebody can say, you need to fix this and this and this, just like we already have for, SOC 2s and all of the different the FedRAMPs and stuff out there. Like all of these things are complicated, and there are answers to all of these questions about, how do you have to store and encrypt PII data in your system, for example. So I think it's just a little bit of a Wild West right now, because we haven't gone through and asked all of those questions.
And I assume the third-party assessment companies are just going to bolt on this whole service offering. Even the EU AI Act, even the European Union talked about there was no real known source of third-party validation of compliance with the Act. It was a skill set that would need to be created. That's one reason for the 2-year effective date, 2-year deferral. And the Colorado Act, as granular as it is and as similar as it is to EU, is a February 26 effective date. So there's time, and I think it's more about making the best use of that time in your use of development of technologies.
Yeah. Yeah, good. So anything else in the California laws we should cover? Or should we
I think that's it for the moment. We'll see what Newsom does. I think these two will get signed. I'm not sure. There's some other that apply to platforms of at least 1 million users, and so there's certainly the social media and big tech is and children's rights, kind of what the federal government is analyzing. Well, there's a lot that's going to roll out over the next few months.
Interesting.
Plenty to talk about.
Yeah, well, we'll keep tracking it and keep going on that one.
Yeah.
Well, what else did you want to talk about today?
That was I thought the hot item was, is Newsom going to sign this, and what does it do on AI systems?
Yeah. Yeah. In our last talk, we had this conversation around OpenAI's terms. I think we're going to do yet another talk where we really just hit on that of, different, where should you be cautious with which of the open platforms. And, that's probably with some of these new laws coming, that's also going to be a moving target, because, if they are suddenly required by law to disclose more clearly what data they're using to train their models, then and maybe they will be a little bit more open about when they're using your prompts and your outputs and your data and when they're not.
Yeah, I think that's right. I've pulled a couple of terms of use, and they're confusing about how they claim the right to use the outputs for their own training their model, which seems inconsistent with the fact that you retain your rights to it. So I want to do a little more homework on those terms of use.
Yeah, absolutely. So we got another question coming in here, Steve, for you. Do you think it's practical, because the model is not frozen in time, it will need to be retrained multiple times after its initial implementation, perhaps with new data? Is it expected to keep this document, the AB 2013, this document updated every time the model is retrained?
Well, that's the complication of having to somehow pull particular user data out of the model. And the risk assessments in the pending California proposal do require annual updates to these risk assessments. I think it kind of depends on certainly the general compliance requirements in the EU Act and the Colorado Act is continually testing and monitoring the performance of the models to make sure that it's secure, resilient, continues to produce the output you expect. So there's a lot of, anticipation of data drift, that the model is going to continue to move and it must be continuously tested. And I don't think that the reporting won't be required to be changed every time, but again, they seem to be headed for annual reports.
Okay, so it's going to work the same as a lot of the existing data privacy, security, compliance tools.
Right.
It sounds like they're really modeling it after that, where you need to be secure with your data year round. You need to prove it to an auditor once a year that you are doing things on a daily basis that keep you secure. So, I think it comes back to understanding the process and having a very well documented and repeatable process as you're, if you're retraining your models every week, every month, that needs to go through a process that you can really, describe to the auditors and understand for yourself and document clearly.
I think that's true. It's like in the data breach, data security, of having a written information security program that is a policy that's repeated and honored. So I think you're right. I think that's the way it's going to play out. It's a lot of administrative effort. It's overhead, it's time effort. So the developers that want to just kind of run and gun with the technology, I think that's the key message, to be careful.
Yeah. Good stuff.
Well, it's a lot.
Yeah, it's a lot to keep up with. I think we'll do this again in a couple of weeks. We'll talk through whatever the latest upcoming is and take some more questions. I think for now, unless you had anything else you want to touch on, we can wrap up for today.
I think that's good. No, I appreciate it.
All right. Thanks for your time, Steve. Thanks to everyone for joining and for the great questions. And we'll see you next time.
Sounds good. Thank you.